of business is a debate on motion 23917 in the name of Claire Baker on the Culpable Homicide Scotland Bill at stage 1. Can I ask those who wish to speak in the debate to put their R in the chat box, please? And can I say to everyone that we have no spare time at all in this debate? And I call on Claire Baker to speak to and move the motion for up to 6 minutes, please.
Thank you, Presiding Officer. I'm very proud to be introducing the Culpable Homicide Scotland Bill today. Families across Scotland who have suffered the death of a loved one at work have fought hard for justice. I want their voices to be heard and for us to commit to use the powers of the Scottish Parliament to fully recognise the crime that has been committed. If culpable homicide can be identified as the cause of the death, it should not matter whether that is by the actions of an individual or by a small or large company. The treatment under the law should be equal, and this is what the bill proposes to do. Natalie Woods is a supporter of the bill who came to Parliament to speak to MSPs, and I'd like to thank all MSPs who signed the bill. Here is Natalie's experience. On April the 16th, 2002, our dad, John Woods, went to work and never came home. His employers were never charged with any offence, and we were never given any explanation why this was. Nearly 19 years later, we miss our dad each and every day. We must live with the injustice of losing a loving dad with very little understanding of what happened and why no one was held to account. Our family deserves justice. These are the voices we should be listening to this afternoon. I want to thank the Justice Committee for their Stage 1 report, and while I do appreciate the difficult circumstances we are all working under, it is frustrating that the bill was not afforded suitable time at committee to hear from families and trade unions who have long campaigned for this legislation. While we have failed to tackle this long-standing injustice, the most recent annual figure is that 19 people are killed in work-related incidents in Scotland on average each year, the highest rate in the UK, which are investigated by the HSE. The most recent figure records 29 deaths in 2018-19, and that excludes marine, air or rail and road investigations. The bill does not amend any health and safety legislation, but it can be a lever to ensure employers take these responsibilities seriously. At present, common law determines how culpable homicide applies to individuals, and it can be possible to convict the owner of a small business when an employee has lost their life due to the business's neglect. However, we need to be honest and recognise there is no expectation that a large business can be successfully pursued through the criminal courts. The current legislation is inadequate and the law is applied inequitably. I am very disappointed by the Scottish Government's response and their lack of support for the bill, not least because when in opposition, many SNP MSPs, including the Deputy First Minister, supported Karen Gillan's very similar bill. Nicola Sturgeon wrote to Families Against Corporate Killing in 2006 to say, "The SNP is supportive of this legislation, and in particular legislation specific to Scotland. It is regrettable that the Scottish Executive has not shown leadership in this issue." Presiding Officer, I know how she feels. To support the principles of this bill in opposition and then not take action in government once the SNP have power, leave them open to accusations of being supine. There is still time this afternoon to change that. It is perhaps not surprising that the Scottish Government responds to the Committee's Stage 1 report defends the 2007 Corporate Manslaughter and Corporate Homicide Act. The Government have previously claimed that it's an effective deterrent that sends a robust message. Along with affected families and the trade union movement, I strongly disagree and believe that the fact that there has not been one prosecution in Scotland under the Act in the 13 years since it was passed, while deaths at work have increased, shows the inadequacy and ineffectiveness of the legislation. Is the Cabinet Secretary really confident that the 2007 Act could respond to another tragedy such as the Transco gas explosion? There is no evidence to support the argument that the 2007 Act bypasses the Transco loophole. The 2007 Act and the senior management test are not working, and we can use the powers of this Parliament to change that. I acknowledge the Presiding Officer has given a negative legislative competence certificate. I would urge the Scottish Government to recognise there is a strong counter view to this, that the bill is clearly concerned with Scottish criminal law, which we have responsibility for, that Section 29(4) of the Scotland Act sets out the provisions for legislating in this area. The bill is not legislating on health and safety. and we do have a responsibility to take action. The Scottish Government have previously challenged the Scottish Parliament's legislative competence on the minimum price for alcohol and defended it to the last, and more recently proceeded with the Continuity Bill, which also had a negative legislative competence certificate. The strong words from Pat Rafferty from Unite Scotland expresses the anger and disappointment of the trade union movement. He says, to suggest that the bill is not competent is not only misleading but factually incorrect. We believe that the issue comes down to political will. In light of the Scottish Government's pathetic lack of will to use the powers already at its disposal, including criminal justice law, it is up to the Scottish Parliament to take a progressive stance. The Scottish Government also argued that I should wait for the Scottish Law Commission review of homicide. The Scottish Law Commission review is not due to conclude until 2023, and the Government's response also makes clear it is not considering the areas which are covered by my bill. My decision to bring forward legislation has been described as a failure to give consideration to this option by the Government. Presiding Officer, what is a failure is that a family lost their lives in the Transco gas explosion and there was no conviction of culpable homicide. It is a failure that Scotland's rate of workplace fatalities is not reducing but is on the increase, and it will be a failure of political leadership if this bill falls today. Presiding Officer, this is a short debate and I have thought in the time I have to set out the reasonings for the bill and respond to the Scottish Government's points. I would appeal to members across the Parliament, many of whom have supported this bill to this stage, to ask themselves how long do families have to wait for justice, and support the bill through to the next stage this afternoon. I move that the Parliament agree to the general principles of the Culpable Homicide Scotland Bill.
Thank you, and I now call on Adam Tompkins to speak on behalf of the Justice Committee for up to 5 minutes, please, Mr Tompkins.
Thank you very much, Deputy Presiding Officer. The Justice Committee is awash with legislation. Today we've published our Stage 1 report on the Domestic Abuse Protection Bill. Next week we have Stage 2 of the Defamation Bill, and very soon thereafter we'll have Stage 2 of the Hate Crime and Public Order Bill. All of this is government legislation, and it is so time-consuming that since I became the committee's convener last summer, we've had no opportunity to undertake any inquiry work of our own. We have, however, been able, albeit briefly, to consider 2 members' bills, of which this is the first to come to the Chamber. We took evidence on the 6th of October from Claire Baker, the member in charge of the bill, and from Patrick Maguire of Thompson's solicitors, and we published a short report on the 13th of November. We asked for the Government to respond to that report before today's Stage 1 debate, which they did on the 12th of January, and I thank the Cabinet Secretary for that. And I thank also Claire Baker and her team for the constructive and helpful way that they engaged with the committee. Our report outlined what the bill does and summarised the policy intentions that underlie it, and I need not repeat here what we've already heard about these matters from Claire Baker this afternoon. And the report outlines too the reasons why the presiding officer has stated that in his view the bill would not be within the legislative competence of the Scottish Parliament, and we noted that the member in charge of the bill respectfully disagrees with that view. Presiding Officer, given the constraints under which the Justice Committee is working at the moment, constraints imposed not only by the burden of government legislation but also of course by the impact of the pandemic, we were able to reach only the following conclusions. First, that members' bills are an important part of the Parliament's work, and that this bill in particular is very important indeed to a number of grieving families in Scotland who have lost loved ones at work. Second, that the number of cases successfully prosecuted in Scotland under existing corporate manslaughter and corporate homicide legislation is vanishingly small, and indeed that this has a devastating impact on families affected. Third, that as such the committee has some sympathy with the policy intentions underpinning this bill, but that at the same time a number of issues have been raised in relation to the bill, both in the committee's questioning and in Claire Baker's own consultation on the bill. And fourth, that the dispute about the bill's legislative competence may lead to a challenge in the courts were the bill to be enacted. On the basis of these considerations, Presiding Officer, the committee made no recommendation to the Parliament as to the general principles of the bill. As I mentioned, we asked the Government to respond, and the Cabinet Secretary's response was received earlier this month. It makes plain, as I'm sure we shall hear in a few moments, that the Scottish Government has a number of policy and legal reservations about this bill and cannot support its general principles. The Justice Committee expressed no final view on this, but my own view, Presiding Officer, in the light of the evidence we took and in the light of the Cabinet Secretary's detailed and considered response to our report, is that I find myself regrettably unable to support the general principles of this bill, and I will vote accordingly at decision time today. Thank you.
Thank you very much. And I call Hamza Yousaf for up to 5 minutes, please.
Presiding Officer, I want to begin by saying the Scottish Government has a great degree and a great deal of sympathy with those families who have lost a relative while attending their workplace, and appreciate the aims of this bill will be important to those affected. I thank Claire Baker for reading out the personal testimony of just one family, but I know she is engaged with a number of families in relation to this bill. Where the evidence shows such deaths have happened because of organisational or management failure, I fully support law enforcement agencies taking robust and effective action if they consider that it is appropriate in a given case using existing laws. I know that those who support this bill believe that the existing criminal law is inadequate. The Scottish Government has made it clear that if current legislation could be improved by new devolved legislation, we will consider what further steps should be taken. And let me say from the offset, although the Scottish Government is unable to support this bill, and I will go into details for the reasons why shortly, I have already spoken to Claire Baker to say that, of course, dependent on election results, I would be happy to discuss these matters in the next Parliament with Ms Baker to see if we can address the concerns she raises in a way that is within the Parliament's competence and in a way that is able to allow any bill or any proposals to be afforded the appropriate scrutiny. I appreciate the constraints the committee were subject to in undertaking the stage 1 scrutiny, which we've just heard from the convener, and I know it made no recommendation to the Scottish Parliament on the general principles of the bill. Therefore, in the absence of full scrutiny, the Scottish Government's ability to analyse this bill has been limited, as our views on it would have been shaped, of course, by a full scrutiny process. Just by way of example, no oral evidence was able to be taken from the Scottish Government, from the Crown, from trade unions, from businesses, and so on and so forth. Again, that is not a criticism at all of the committee, because they do have a full workload, and that is due largely, overwhelmingly, because of the Scottish Government legislative timetable. However, on the basis of an examination, I can make the following remarks. The Scottish Government notes this bill has obtained a negative legislative competence certificate from the presiding officer. Based on a very preliminary analysis of the competency of this bill, the Scottish Government is also of the view the provisions in the bill which give effect to the policy intention behind it are out with the legislative competence of the Scottish Parliament. We are also of the view that it would be difficult to amend the provisions of the bill at stage 2 so as to bring it within competence without significantly changing the policy intention behind the bill. Any doubt about competence could call into question future prosecutions made under this bill if passed. And that is something we need to consider very, very carefully. This would not be a desirable outcome and may lead to the Lord Advocate having no other option but to make a reference to the Supreme Court as to the legislative competence of this bill under Section 33 of the Scotland Act 1998. There are also a number of policy concerns the Scottish Government has. The first concern is the way the bill seeks to operate within the common law of culpable homicide. With the Scottish Law Commission's review on homicide underway and due to report in 2023, the Scottish Government would be concerned about any piecemeal reform of the law. I think it's preferable that reform of culpable homicide as it applies to organisations be considered once a reform homicide criminal law is in place, though I accept this does not definitively have to be the case. Our second policy concern is around the lack of clarity as to how the process of aggregation under Section 2, subsection 3 of the bill would operate. In particular, it's not clear how a jury would assess when such individual actions, which do not, considered separately, constitute culpable homicide, are somehow sufficient, as the bill refers to it, when considered together for these purposes to provide that an organisation has committed culpable homicide. The bill does not set out what tests would apply. In our view, there's also a lack of clarity as to how the rules under Section 6, Art and Part, operate and whether this approach is correct and fair. It would appear that provisions would apply even where the organisation has only been found guilty on the basis of aggregation under Section 2.3. Thus, there is at least a possibility that an individual could be found guilty art and part, even when their actions viewed in isolation do not constitute any criminal offence whatsoever. There's also a lack of clarity in the way that this bill will interact with existing provisions in the UK Government Corporate Manslaughter and Corporate Homicide Act 2007. So in conclusion, Presiding Officer, the Scottish Government is happy to consider any proposals for reform to the law in this area if they can be developed within the competence of the Parliament. It is not a lack of political will, and I am disappointed that it is being characterised in such a way. There are very clear doubts over the legislative competence of the bill, and any doubts about competence are not just theoretical. They could call into question future prosecutions made under this bill if it is passed. Alongside these competency concerns, the government would be concerned about piecemeal reform of the law, and of course we have policy concerns, and indeed the fact that this bill has not had the detailed scrutiny one would expect it to have at stage one. So, Presiding Officer, for all the reasons given, the Scottish Government finds itself unable to support this bill.
I call Liam Kerr, and you have 4 minutes, please, Mr. Kerr.
Thank you, Presiding Officer. I'm very pleased to have the opportunity to speak in today's debate. Scottish Conservatives will vote against the principles of the Culpable Homicide Scotland Bill at decision time tonight. But that phrase is interesting because I have sympathy with the principles of this bill and those who have lost loved ones. Claire Baker, who introduced the bill, did so on the basis that the principle, if you like, that a person or organisation which causes a death can be found guilty of a suitable offence and make clear who is responsible. The policy memorandum is succinct, that its intention is to make clear in statute, yet not in substitution for the common law offence of culpable homicide, what the offence is, what its elements are, and who may be liable. That, the member says, would reflect the moral opprobrium that society attaches to taking a life, but also drive behaviour change, particularly in relation to safer working environments for employees. Admirable, but we cannot vote this bill forward today. Firstly, because the member knows I'm deeply uncomfortable with the current legislative timetable in the justice portfolio and its impact on our ability to scrutinise proposed legislation. The convener described the committee as awash, and he's right. The Justice Committee itself felt unable to make a recommendation to the Scottish Parliament on the general principles of the bill today because we had only one session to review it. And in that we heard only from the member and one other for a bill which in its effect could be groundbreaking and requires the utmost care. There is very limited time left for consideration and scrutiny in this session, and I cannot countenance voting for something of such potential import through. Secondly, on the 1st June 2020, the Deputy Presiding Officer issued a clear and unambiguous statement that, in my view, the provisions of this bill would not be within the legislative competence of the Scottish Parliament. Now, on the same day, the member says her view is that it would fall within competence, yet, in contrast, gives no reasoning for that. I also have regard to the Cabinet Secretary's letter of the 12th of January, in which he persuasively contends this bill is not within competence, and also raises the concern that, were this bill to pass, there could be a successful challenge, and the Cabinet Secretary has set out the implications of that in his remarks just now. Now, others will look in detail at the policy concerns inherent in the bill, including the significant danger of unintended consequences. So I'll finish simply by referencing the Scottish Law Commission's review. I find myself in agreement with the Law Society, and for completeness I remind members I am a practising solicitor with membership of the Law Society of Scotland. I find myself in agreement that whilst a considered and detailed review of the law on culpable homicide is necessary, it already forms part of the work being currently undertaken by the SLC with its review on homicide. Now, the Law Society reassures that when the SLC report is issued, it will provide a set of recommendations and collection of evidence upon which to proceed with reform of the law in this area. Now, as well as providing authority and ensuring legislative competence, that would avoid a piecemeal approach to amending the crime of culpable homicide. Now, I understand the member's view that this has taken some time, and even following the report, there will be a time delay until legislation, but I cannot help but conclude that that is the best and most appropriate body to be considering this, in order that when the Parliament does come to consider any bill, it does so in the context of a full review which deals with any legislative competence, and any criticisms of piecemeal reform can be easily challenged. In summary then, Presiding Officer, the Scottish Conservatives do have sympathy with the families who've lost a relative at the workplace, and do appreciate the members' intentions, but we will vote against the principles of this bill at decision time tonight.
Rhoda Grant, please, for up to 4 minutes.
Thank you, Presiding Officer. Can I begin by paying tribute to Claire Baker? Bringing forward Members' Bill takes tenacity and hard work, and she's displayed both. The bill recognises that too often people die at work due to the negligence, but all too often no one is held to account. For families, it's heartbreaking to lose a loved one is devastating, but to know that those who caused their death due to recklessness or gross negligence are not being prosecuted must be unbearable. They can't get closure. Louise Taggart lost her brother and has said, far too often families like mine who have been bereaved by work are left to feel that we have failed our loved ones because the justice system has utterly failed us. Neither does this situation enforce adequate safety standards. If companies are not held to account, they are actively being encouraged to cut corners, which puts their workers' lives at risk. There is an offence of corporate homicide, but not one single person has been convicted under it in over 12 years. And this is despite the fact that an increasing number of people are dying at work due to negligence. Ros Foyer, the General Secretary of the STUC, said, "The bill is vital to workplace safety in Scotland. The 2007 Act is not working, and it is vital that legislation is passed that can be effectively applied to larger organisations. Yet the Scottish Government is doing nothing. The current situation is unacceptable, and Claire Baker's bill tries to address this. Workplace deaths are sadly increasing and are higher in Scotland than the rest of the United Kingdom, and therefore this bill is desperately needed. It is supported throughout the trade union movement and by families who have lost loved ones due to unsafe working conditions. It's also simply hypocritical of the government, whose members have supported the proposed legislation while they were in opposition, but now, when they are in power, are choosing to vote it down. This is far too important to play party politics with, and I would urge them to change their tack and support the bill at stage 1. I also find it unacceptable that they vote down a bill tonight simply because there has not been enough time for scrutiny. That is not to say we don't need scrutiny, we do. But if there is not time to do that scrutiny during stage 2, then the bill itself would run out of time and fall anyway. If there is time, scrutiny can take place before amendment, and we can make a final decision on the amended bill at stage 3. There are enough checks and balances in the system to allow this bill to pass tonight and be properly considered by the Parliament. The general principles of this bill and what it is trying to achieve is sound, and that's what we're voting on tonight. Therefore, if you believe families who lose loved ones due to the recklessness and negligence of their employer need redress and closure, then you need to support this bill tonight. If the government cannot get control of COVID-19 and the election is delayed, there will be ample time to do this scrutiny. If not, the bill will run out of time and fall. We lose nothing by supporting the bill at stage 1, and families and workers have justice to gain. I will leave you with the words of Louise Taggart. She said, "It is time for this whole Parliament to unite and show leadership and help put an end to the future work-related heartbreak to prevent other 26-year-old men like my wee brother with their whole lives ahead of them from going to work in the morning and not making it home. Taking forward these proposals is about justice. It's about saving lives. It's about protection of family members. Families deserve justice. Families expect you to act without any more dither and delay, putting aside party politics. I urge members to support this bill tonight."
Call John Finney, please, for 3 minutes.
Thank you very much indeed, Presiding Officer. I congratulate Claire Baker and her team for getting this far. I'm a signatory of the bill, and the Scottish Green Party will be supporting it at decision time tonight. I think this is a complicated area of law. If there's any debate about that, we would refer people to the Law Society's briefing, which has an appendix which is a brief outline of the existing law, which seeks to emphasise its complexity. So that is readily accepted. We can't wait for the Law Commission. It's simply untenable. The status quo does not deal with the reality of the situation faced with workplace deaths. As regards legislative competence, well, I'm elected to push the boundaries of issues. I think the member is right to say that it is within the competence, and she's right to highlight two issues where the Scottish Government pushed, namely the continuity bill and the minimum pricing. I also want to commend Patrick Thompson, Patrick Maguire of Thompson Solicitors and Scottish Hazards for their outstanding work on this. Now, reference has been made to Transco. I fear that we don't have the time, even in this debate, to go into detail, but what we do know is that Transco were found to show a complete and utter disregard for the public quote, but the charges of culpable homicide were held as irrelevant and were subsequently dismissed. Now, the member believes that we have to act, and I absolutely share that belief, and we must act using the powers of the Parliament. And the response the government say a lack of prosecutions does not necessarily lead to the conclusion that it's not fit for purpose. I thoroughly disagree with that point. And the Scottish Government also highlights the legal term identification principle and the significant danger of unintended consequences. I utterly disagree again. Surely the purpose of parliamentary scrutiny is to address the identification principle head on and to ensure no unintended consequences. To veto at this stage, to not allow the debate to continue, and the proposals to define seem highly selective, and it is disappointing. It's also very frustrating the limited time we do have to discuss this. I want to read a quote from Patrick Maguire. We say that if a responsible person, such as a supervisor or manager, to whose level authority has been delegated down within the company, acts recklessly or causes a death for a gross breach of a duty of care, that individual forms the guilty mind because they are acting as part of that delegated authority. And there is also a link to the company. There's extensive support, Presiding Officer, for this bill. The bereaved loved ones don't want sympathy. They don't want expressions of sympathy. They want action. And most importantly, they want their Parliament to act on this significant failing. And I hope that that's what members will do at decision tonight. Thank you.
Call Liam MacArthur for 3 minutes, please.
Thank you, Deputy Presiding Officer. In customary fashion, let me also start by thanking Claire Baker for bringing forward this bill. As I said in relation to the Protection of Retail Workers Bill passed by Parliament earlier this week, no one should underestimate the work involved in taking forward a member's bill. While Scottish Liberal Democrats can't support the bill as proposed for reasons I'll come to shortly, I want to make clear that the issues and concerns being highlighted by Claire Baker through her bill are legitimate and will require to be addressed. Indeed, I want to acknowledge the earlier campaigning and efforts of my friend and Claire Baker's former colleague Karen Gillan, which led to the Corporate Manslaughter and Corporate Homicide Act 2007. It was recognised, I think, at the time that this did not go as far as Karen Gillan and others would have wanted, but a bridgehead has been established. As we now know, the existing offence of corporate homicide introduced by the 2007 Act is yet to be prosecuted in Scotland. So I recognise entirely why Claire Baker is seeking to strengthen what are seen to be deficiencies in the current law. I understand the frustration that the 2007 Act appears to set the bar for prosecution relatively high, particularly when it comes to attributing a breach to individuals within the senior management of larger companies and organisations. However, as the Justice Committee heard during the limited evidence we took on this bill, there are serious questions about its legislative competence. The Presiding Officer has made clear his position in terms of the reserved nature of both health and safety as well as law relating to corporations. Whatever our respective positions on where those powers should lie, and I note the comments of John Finney, the member in charge, and others in relation to how we might test that at stage 2. I can't see how this can be simply wished away in order to allow the bill to pass to stage 2. Certainly, as the Law Society has suggested, there's a strong case for reviewing the 2007 Act. Indeed, at the start of a new parliamentary session, before government bills begin appearing, it could be an ideal opportunity for a successor Justice Committee to undertake just such a post-legislative scrutiny. If it were to do so, the consultative and other work carried out by Claire Baker, I'm sure, will be invaluable to informing deliberations and identifying potential ways forward. I would hope also that the work being carried out at present by the Law Commission into the law of homicide might usefully look at this area in particular. At this point, however, much as the Scottish Government has concluded, I'm not persuaded of the case for passing this bill to stage 2, particularly given the workload pressures already on the Justice Committee in dealing with the legislation before it. Nevertheless, like Karen Gillan before her, Claire Baker deserves huge credit for ensuring that a light continues to be shone on the issue of culpable homicide, making it more likely that the concerns she quite rightly raises on behalf of families affected, but also the wider public, will ultimately be addressed. Thank you, Deputy Presiding Officer.
Thank you, and we'll move to the open debate. Speeches of 3 minutes, please. Kenneth Gibson, followed by Gordon Lyndhurst.
Thank you, Presiding Officer. Culpable homicide legislation needs updating, and this bill has been introduced with the intention of doing that. And much like case law and indeed language used when talking about culpable homicide dates back to a time when we had the death penalty for murder. However, the bill, which seeks to amend the law by effectively creating 2 forms of culpable homicide, deals only with one aspect of homicide law and attempts to modernise this without addressing wider issues which may need reformed. The Scottish Law Commission has launched an extensive review into homicide law due to be completed by 2023. It will assess the principles underlying and the boundaries between the crimes of murder and culpable homicide and the psychological element required for the commission of these offences. It also aims to review the nature, scope and definitions of the main defences arising in cases of homicide, including self-defence, provocation and diminished responsibility. This important and comprehensive review may well show a need for current laws to be improved or supported by new devolved legislation. If this is the case, the Scottish Government should at that point consider new legislation itself. And every workplace fatality is a tragedy for that person's family, friends and can be traumatic for work colleagues. I therefore greatly sympathise with the intentions behind this bill. That said, before the completion of the Commission's review, this bill risks a premature, piecemeal approach to reform. Any reform of culpable homicide as it applies to organisations should only be considered once a reformed homicide criminal law is in place. This bill was introduced on the 1st of June 2020, and by this stage we would normally expect it to have been subjected to careful scrutiny by the Justice Committee, and Parliament would have received a recommendation on further action. In the Stage 1 report on the culpable homicide bill, the Justice Committee warned that scrutiny has been significantly constrained, as we heard from Alan Tompkins and Liam Kerr. Understandably, lockdown restrictions resulted in a delay in the committee's work programme, and its exceptionally busy schedule impacted the time available to scrutinise this bill. While nobody's fault, the upshot is that the committee has not been able to scrutinise the bill to its usual high standard, nor make recommendations based on that scrutiny. Even so, the committee raised significant legislative competence and policy concerns regarding this bill, agreed by the presiding officer. But just because we want this bill to be competent, sadly, does not make it so. And it shows the need for further, more in-depth scrutiny, and suggests the bill has been brought to the Chamber prematurely. As previously mentioned, I'm sympathetic to the intentions behind the bill and thank Claire Baker for her hard work in bringing it to Stage 1, and I realise how frustrating it must be for her that it doesn't have greater support today. However, passing the bill without appropriate scrutiny or a full understanding of the consequences would be irresponsible. Presiding Officer, while it can be tempting to rush through legislation, particularly on very important and emotive issues, we must ensure it is comprehensive, complete, holds up to scrutiny, is competent and will deliver. Sadly, this bill doesn't fulfil these criteria, and therefore I cannot support it.
Gordon Lyndhurst, please, followed by Alex Rowley.
Thank you, Deputy Presiding Officer. The Scottish Conservative approach to this bill has been outlined by my colleague Liam Kerr, and I need not repeat what he has said. Perhaps 1 or 2 comments would be appropriate, however, at the outset. There is the key issue touched on by many already of whether the measures this bill aims to put into law fall out with the competence of this Parliament. Indeed, they've already been considered to do so. Without a well-reasoned explanation of why that view is wrong, it would be difficult to deal properly at this late stage in the session with it. It is, of course, of concern that much time has already been spent, some might say entirely wasted, during the course of this session on other measures which are out with competence and on yet others of dubious competence. But a further key point, which is really unrelated to the bill itself, is of course the current circumstances of which we are all too painfully aware. The various measures which have been put in place as a result, which of necessity impinge upon and to a very real extent prevent the proper exercise by us as MSPs of our democratic functions in the carrying out of the responsibilities. Such as these can be exercised at present, doing so adequately is neither easy nor quick, including for the Justice Committee. Virtual meetings and online communication are not equivalent to meeting in person at all. It is quite clear that these IT solutions do not provide equivalence at any level. I recall visiting a tech hub in the before time, as some refer to life pre-COVID, and being told by the highly successful IT entrepreneur that if he really wanted to get something sorted out, he got everyone together in a room because online meetings just didn't do it. It is, of course, very important, as has been emphasised by others, to recognise that the bill's intentions are well meant. The onus must always be on individuals and organisations to act in responsible ways, which is why the law already recognises this in the controlling mind principle. And imperfect though the current state of affairs is, the matter requires to be addressed very carefully indeed. So in the current circumstances we face at the end of this legislative session, the matter, if thought appropriate, would perhaps be best considered and acted upon in the next Parliament. Thank you.
And the last of the open debate contributions is from Alex Rowley.
Thank you, Presiding Officer. Scottish Hazards, along with trade unions and campaign lawyer Patrick Maguire from Thompson's, have always said that families affected by workplace deaths are being denied justice. Now, Hamza Youssef today says that he has a great deal of sympathy for families, but the clear message is that families need more than sympathy. What they need is a change in the law. And I would like to read from comments from Denise Christie, the head of the Fire Brigades Union in Scotland, where she said the current legislation is completely ineffective. After 13 years, there have been no prosecutions, let alone convictions, under the legislation in Scotland at all. The legislation is drafted in such a way that medium-sized and larger organisations are almost never likely to be prosecuted. We believe it protects companies from prosecution and fails workers and their families. And that's what Claire Baker, along with a lot of support for others, has worked so hard to address. And I think it is absolutely appalling that the Cabinet Secretary comes along here today with excuses rather than looking at how we can take this to the next level, which would be stage 2, and work to see if the concerns that the government have can be addressed. That at least should be the principal starting point from this government. The health and safety at work has been a good piece of legislation, the FBU say. However, it doesn't reflect the gravity of the crime. An organisation's reputation is one of their most valuable assets. If a company is found guilty of Section 2 or Section 3 of the Health and Safety at Work Act, it doesn't have the same impact as being found guilty of culpable homicide. The reputational damage to any company, and they say that organisations are now no longer deterred by the current legislation, and they know that the chance of being prosecuted in Scotland under this is almost non-existent. So I want to thank Claire Baker, thank the trade unions. Let's get this sorted out. I appeal to the Cabinet Secretary, agree this to go forward today for stage 1, and let's continue the discussions and see if it can be fixed. Thank you.
We now move to the closing speeches, and I call James Kelly. 4 minutes, please.
Thank you, Deputy Presiding Officer. I'd like to start by paying tribute to Claire Baker for the fantastic amount of work she's put into this Members' Bill on a very, very important issue, which means so much to the families that are affected by it. It's not just the statistics that Claire quoted in terms of the way the number of deaths are increasing over the last decade. It's the stories and the testimony behind that. And as Alex Rowley pointed out in the FBU testimony, there's clearly a gap in the law here because people are dying at work and companies have not been held responsible, and families are left with nowhere to go on that, and that is a clear failure. Those who argued against the progress of the legislation today have made 2 points. First is around legal competence. I've studied the presiding officer's statement, I've listened to the Cabinet Secretary. However, I think that the supporters of the bill and Claire Baker make a very powerful point that this can be taken forward under the Scotland Act, section 29(4), and I think that we should use further consideration of the bill to explore that. The second point that has been made is around the supposed lack of evidence and the timetabling considerations. In terms of evidence, this issue has gone all the way back more than 15 years, as a number of speakers referred to the work that Cam Gillan did, and which was then taken forward by Richard Baker. So there's a formidable package of evidence there already. And I think, as Rhoda Grant pointed out, there's clearly a question mark over the date of the election because of the ongoing restrictions for the pandemic. So I think it's reasonable to allow the bill to pass at stage 1 in terms of the general principles to allow further consideration. We've heard contributions from a number of members, including Liam Kerr and Humza Yousaf, to say that they were very sympathetic to the principles of this bill, but they didn't want to take it forward. And quite simply, I think that is just not good enough. This is an issue that has been around for more than 15 years, and it's a failure of devolution that large companies essentially are going unprosecuted where these fatal accidents are happening at work. So I think that the government and all parties need to take more responsibility on this. Final point I'd make is that if you listen to the testimonies of those who have been affected, Rhoda Grant quoted Louise Taggart and Claire Baker quoted Natalie Woods. It's an absolute tragedy that someone leaves to go to work and they don't return home. It's terrible, terrible for their loved ones. And I think it's simply not good enough for MSPs and political parties to kind of wring their hands and say, oh, we don't have enough time, or we've got some legal considerations we're concerned about here. Let's try and use the time that we've got. Let's stand up and be a voice for our families. That's what Parliament's all about. Let's try and make a difference. Let's let the bill on to the next stage. Let's have further scrutiny and see if we can get this work and get a solution. I urge people to support it at decision time.
I call Margaret Mitchell for 4 minutes, please.
Thank you, Deputy Presiding Officer. I will also want to begin by paying tribute to Claire Baker for the immense work that she's put into researching, consulting and the drafting of this Members' Bill, and I thank the Justice Committee for its scrutiny of the Bill and the Stage 1 report. Under the Corporate Manslaughter and Corporate Homicide Act of 2007, which applies to the whole of the UK, 250 cases have been prosecuted, but only 9 have resulted in convictions. The number of people killed in Scotland while at work averaged 19 per year, but despite this, the Crown and Procurator Fiscal Service have raised no prosecutions. Currently, in order to bring a prosecution, the controlling mind of an organisation must be identified. It is easier to establish this in smaller organisations as compared to larger ones and corporations, where often large and complex management structures make it hard to identify who in a business or organisation controls the actions that have led to a death. Section 1 of the Culpable Homicide Scotland Bill creates 2 different categories of statutory culpable homicide that apply to individuals and non-natural persons alike, where a death has been caused by reckless or gross negligence. Section 7.2 grants powers to Scottish ministers to, by regulation and subject to affirmative procedure, add, remove or modify a description of a non-natural person. Whilst this flexibility has been welcomed by some, Others have raised significant concerns in terms of the legal ramifications and possible changes to the criminal law. The law must give certainty, and this flexibility has been viewed by employment law experts as a weakness in the bill. However, whilst it may be possible to address the flexibility and other issues, the Justice Committee has highlighted, this is unlikely to be done by amendment, but at the same time, but at the same time, it would be difficult to resolve the legislative competence issue. Given the PO has ruled the bill is not within the legislative competence of the Scottish Parliament for the following reasons. It relates to Part 1 of the Health and Safety at Work Act, which is reserved, and the bill as a whole relates to the operation and regulation of business associations, which is also reserved. Deputy Presiding Officer, no one could fail to be moved and have sympathy for the heartbreak suffered by the families of those who left home for work as normal but never returned, having lost their lives due to an accident at work. Consequently, the lack of convictions is most certainly a cause for concern. But the fact remains, the bill has been ruled as not within the legal competence of the Scottish Parliament. This in turn has prompted the Justice Committee to question whether there is merit in the bill proceeding to stage 2, given the limited time available for further consideration in this session of Parliament. And it's for these reasons disappointing, and I know will be for Claire Baker, that the Scottish Conservatives will not be able to vote in favour of the Culpable Homicide Scotland Bill this evening. Instead, we agree with the Law Society of Scotland that post-legislative scrutiny of the 2007 Act would establish if there is empirical evidence to support the criticisms of the Act. Thank you.
Thank you. Call Hamza Yousaf for up to 4 minutes, please, Cabinet Secretary.
Thank you, Presiding Officer. I welcome today's debate. I'm disappointed by some of the characterisations in the debate, particularly from Labour members. A suggestion to those who are not supporting the bill today, do not think of the families or have them in our mind that have been affected by...
Excuse my interrupting, Cabinet Secretary. You're very difficult to hear. If you could speak closer to your microphone.
Officer, those who oppose this bill for very good reasons do not somehow understand or sympathise with the struggles that the families who have befallen these tragedies absolutely feel. So I want to reject that from the outset. Can I say that it is precisely because of our concerns for those families that Claire Baker and many others have spoken about that we think this is bad legislation, and passing bad legislation potentially could lead to any prosecutions being overturned in the future. That is not something to be thought of lightly. We do have concerns about the lack of scrutiny. Scrutiny in this Parliament is incredibly important. Members of the opposition have told us day in and day out, quite rightly, that scrutiny of legislation is important. Whether that is the hate crime bill, whether that is COVID regulations, this Parliament exists to ensure that there is adequate scrutiny of any legislation, be that a government bill or indeed, of course, in this case, a member's bill. The lack of scrutiny is not something that can just be wished away, certainly not on the whim that an election may be postponed. That, of course, of which we do not doubt, and in fact, as things stand, we very much expect the election to go ahead upon its timetable. So the lack of scrutiny is not something that can simply be ignored, and I think it's important that all parliamentarians consider that issue. There is also significant concerns being raised by a number of stakeholders, such as, for example, the General Medical Council. They've raised concerns of unintended consequences on the medical profession and doctors' confidence in reporting and learning from medical errors. That is not an insignificant concern, where all of us absolutely appreciate the work of our healthcare professionals, particularly during the pandemic. To pass a law, a bill, that could have unintended consequences on those very NHS workers without taking any oral evidence from them whatsoever surely cannot be right. The competence issues, of course, as I say, are ones of, again, grave concern. A number of members from the Labour speakers, and indeed I noticed Mr Finney, suggested that we should simply push the boundaries, as we've done potentially with other pieces of legislation. The difference being that in the legislation where the government has pushed the boundaries, there has been, and we have thought there has been, some dubiety about whether or not it has been legislative competence or not. We do not have those same concerns. We are entirely convinced that this bill is out with legislative competence, as is the presiding officer's view. I also note, when giving evidence to the committee, Claire Baker accepted that the issue of legislative competence is an area for debate. She said that the Parliament should be ambitious and brave. However, I noted the convener rightly pointed out, and I quote from him directly, the terms of the Scotland Act 1998 do not refer to ambition, but to purpose and effect. And the convener concluded by saying, I completely understand the ambition, but ambition is not a relevant consideration. The relevant considerations are purpose and effect, and both purpose and effect speak to health and safety, which is reserved. So it's also the Scottish Government's view the provisions in this bill which give effect to the policy intention behind it are very firmly out with legislative competence. And on the issue that was raised by James Kelly in relation to section 29(4) of the Scotland Act, it is very much the Scottish Government's view, as we set out in the response to the Stage 1 report, that provisions in the bill fail the test in section 29(4) of the 1998 Act. There are a number of policy concerns which, again, I won't rehearse, but it is, I think, inappropriate in a Parliament that is designed to ensure that there is adequate scrutiny of legislation to not take appropriate evidence when such significant policy concerns are raised. I appreciate that those who support this bill believe the current criminal law is inadequate. They cite the lack of prosecutions under the UK Government's Corporate Manslaughter and Corporate Homicide Act 2007. The lack of prosecutions under the 2007 Act does not necessarily lead to the conclusion that the Act is not fit for purpose. Every fatality at a place of employment in Scotland is investigated by the Crown's Health and Safety Investigation Unit as a potential corporate homicide. The very nature of these types of deaths means that detailed and lengthy investigations, often involving technical and medical issues of expert opinion, are required, and there have been health and safety criminal offences committed that have resulted in custodial penalties. In March 2015, Guthrie Melville, a shellfish boat skipper, was sentenced to 9 months after being found guilty after trial of a number of health and safety at work. In January 2017, Donald Craig, the manager of an access plant hire firm, was sentenced to the maximum penalty of 2 years imprisonment for breaches of health and safety. And there are a number of other cases that I could refer to. So Scottish Government does, of course, have not just sympathy, but wants to work with the families, but also with other members on a bill that could help to address some of the issues, but they have to be within devolved competence, they have to deal with the policy considerations, and they have to be appropriately scrutinised. And I, of course, will wrap my remarks up there, Presiding Officer.
Thank you. And I now call on Claire Baker to wind up the debate. I can give you up to 5 minutes, Ms Baker.
Thank you, Presiding Officer. I would like to thank members for their contributions in the debate. I recognise the process for scrutinising the bill has been curtailed, and I do appreciate the consideration MSPs have shown this afternoon. I am struck that MSPs seem to recognise and to agree that the current situation is not acceptable. So if not this bill, what are they prepared to do to fix it? I would like to thank Patrick Maguire from Thomson Solicitors for his commitment to the bill and his extensive work on drafting the legislation. My thanks also go to Ian Tasker from Scottish Hazards and Louise McTaggart from Families Against Corporate Killing, who have provided support and briefings which have been invaluable. I would also like to thank the STUC for their strong support for the bill and for their generosity in hosting meetings and events. The contribution and commitment of the trade union movement, who have campaigned for change in this area, the GMB, Unite, Unison, FBU, ASLEF, know the impact it has on their members and their families, and it's been very welcome. And I would sincerely like to thank all the families who've shared their experience with me. This includes families who have had bereavements during the passage of this bill, and have contacted me distraught because they have no confidence in the current justice system and they fear the life of their loved one and the loss they have experienced is undervalued. For those who are concerned about the impact on business, this bill does not require businesses to do anything other than what they are legally required to do now. A business and employers who take seriously the duty of care they have for their workforce and take all necessary measures to prevent injuries and fatalities have nothing to be concerned about. The Cabinet Secretary describes it as bad legislation. I have to say this wasn't the view of the SNP when they were the opposition. I won't repeat the First Minister's comments, but I would ask what has changed. The Cabinet Secretary has raised concerns about the drafting of the sections on aggregation and inaction parts. There are also points being raised about the interaction with the 2007 Act. I recognise that these are areas that need further consideration and I would bring forward or accept amendments to address these. I did meet with the GMC and I would also look at the option of including exemptions. The curtailed manner of Stage 1 has limited the opportunities for dialogue and scrutiny, and I believe, as Rhoda Grant argued, that these can be addressed at Stage 2. It is the amendment stage and I will work with others constructively. I would ask members to consider how we can complete members' bills in this session. Members introduce bills in good faith and in good time, and it's highly regrettable that legislation is being thwarted by time. Unison Scotland are urging MSPs to support the bill at Stage 1. They say, for too long, large businesses have destroyed families with little recompense. It is time for the law to be readdressed. There is a moral imperative to this bill. There is a case that is similar to the ones the Cabinet Secretary highlighted that have had prosecutions under health and safety legislation. Scottish Hazards highlight the view of Sheriff Collins in the sentencing of Craig Services Limited in 2012. She said, "The sentences I am about to impose cannot and do not attempt to reflect the enormity of Mr Curry's death, nor the suffering of the loved ones." Again, the inadequacy and insufficiency of the law was exposed. First exposed by the Transco case, and the 2007 Act was a response to that. But there is no evidence across the UK that the current legislation can effectively deal with the prosecution of a company such as Transco, or even a smaller company such as Craig Services and Access Limited. The FPU have said today that they believe the Act protects companies from prosecution and fails workers and their families. I welcome the Cabinet Secretary's offer to continue discussions in the next section if we are both returned, and Liam MacArthur suggests a committee approach. But sympathy is not enough. We need to have a solution-focused approach and not just be prepared to remain at a standstill with no change. Liam Kerr is not accurate to say that I have not presented an argument that it is competent. I have, and it was shared with the presiding officer and the committee. He and others may not agree with it, but it's unfair to say that I haven't brought forward a case. The bill is wholly concerned with criminal law, and Section 29(4) gives us the power to make modifications of Scots criminal law. I don't agree with the purpose and effect argument. The bill makes no changes to existing health and safety legislation. The pith and substance of the bill is on culpable homicide. It is not concerned with reserved health and safety legislation. I do not accept that as an argument for denying legislative competence. A number of members refer to the Law Commission review, but to be clear, that is not considering culpable homicide cases concerning workplace deaths. My final word on legislative competence is to call on the Scottish Government to think again, to give this bill the same consideration they have given other bills they have themselves introduced, to not accept the current state of affairs, and to agree to work with me to deliver a workable bill and a good piece of legislation that will provide families with a route to justice and help to reduce how often they may need to access it. Presiding Officer, I appeal to members to support the general principles of the Culpable Homicide Scotland Bill and give my commitment to work across the Chamber to deliver justice for families across Scotland.
Thank you, the Speaker. And that concludes the debate on Culpable Homicide Scotland Bill at Stage 1. And we'll now move on to the next item of business.